Today, and to our other attendees, Commissioner Allamby and Lieutenant Montgomery and Sergeant Bombi and Elliot Halpern of the ACLU, and I'm Commissioner Calavita, heading up this subcommittee. And so unfortunately we're missing Terry Roberts, who retired, and so the committee is Gwen Allamby and myself for the time being. We may have an additional member join because we have 2 new members of the commission, both of whom I've approached to see if they're interested, and they're thinking about it, but also thinking about other committees. So for now it's just the 2 of us, which is okay, legally speaking. As usual, we're going to have a free-floating conversation here today with the visitors instead of the more formal rules of 2 minutes at the beginning and at the end, although we'll have that too, in case there's other visitors who want to have something to say. So on the agenda, can I have approval of the agenda, Gwen?
I move.
Yeah, seconded. As you see, I've moved new business first and put the old business second, which is a little unusual, but I've done that for the purpose of relieving Commissioner Prather of having to stay through possibly longer discussion of the language, although you're welcome, and I really would love it if you would stay, because we could benefit from your input there too, but in case you have to leave, we wanted to benefit from your input first at the beginning of the meeting. So here's what we know. We know that the Oakland Police Commission made recommendations for changes to the policy regarding inquiries and parole and probation related searches, and that the Oakland Police Department also had their set of recommendations, which were similar but not identical. And the 2 sets went to the Oakland City Council. I think there was a first round where they were more different, and Oakland City Council asked you to come back after reconciling, and then went forward with the 2. And yours, the commission's, was unanimously accepted by the City Councils. Do I have that right?
More or less,
Can you
yes.
describe in more detail?
Absolutely. So the genesis of our probation parole search policy actually came from the police department itself.
Mm-hmm.
It is one of the things, as you probably the folks in the room are aware, we're under a federal consent decree, and so there's a lot of things that our department has undertaken to attempt to better and change itself, and so the probation parole and search policy was one of those things. They are, I think they're required. I can't necessarily speak to the language in our ordinance that does that, but they're required to come to us with that policy, and so we worked with them on the policy to develop it. At some point, and this is just the history of it, at some point we just came to a point where we weren't going to agree on how the changes were going to be made, and 2 versions ended up submitted to the City Council. City Council then said, look, this is the whole point for the commission, is to be able to work these things out, so it got sent back. We had another few rounds of edits and working with the police department. Again, I think it got a lot tighter, it got a lot better, and there were just a couple of issues that remained, and then ultimately those 2 versions were again sent to the City Council, and the City Council adopted the commission's version. So that's the history of it. It's currently the implementation of it has it hasn't been rolled out widely yet because it's still in negotiation, or it's in the meet and confer process with the OPOA, the Police Officers Union. But we expect that within a few weeks or months it will be able to start training on this policy.
Mm-hmm.
And so one of the things I think that is really unique that we have, that our chief came to us and said, look, this is your policy, the commission's policy, and they're going to allow one of the commissioners to actually attend all of the trainings and actually train on the policy with officers at the, when it gets done, when it gets rolled out. So,
Mm-hmm. Mm-hmm.
so that's our current status.
People have, Gwen, do you have questions that you want to?
I'm happy to go into like a history and just kind of walk you through it, because I think it could be helpful.
Interested in hearing about what challenges you faced and how you all approached them and confronted them, because it seems like you've been pretty successful in moving forward to this point anyway.
Well, I think what is really important to sort of recognize and give credit to is this emanated from the police department itself.
Mm-hmm.
This is something that OPD wanted. This is something that it felt it needed to develop.
Mm-hmm.
This policy went specifically to just better interactions with the citizenry of Oakland.
Mm-hmm.
And I think that's a big issue.
Mm-hmm.
I think every time you have a new policy change or you're rolling something out from OPD, it's an opportunity for us to have better communication with the public.
Mm-hmm.
And that's something that hasn't always been there, whether it be from the commission or OPD itself. And it's an opportunity to sort of market. You have to sort of market yourself, kind of bring in some other disciplines, right? There's a need to not only change the policy, but explain to people why you're doing it, what the problem is, what you're doing, how you're doing it, why you're doing it. Because if you just have the policy, and I think that this is where you can sort of really learn from our early mistakes, is that there was a policy and we weren't telling folks why. And that's why, in the language, and I know there wasn't I don't know if you've seen our policy, because they're
Yes, we do.
in the packet.
We have it,
Okay,
and
great.
we have the department's one too.
Great.
Yeah.
So, we really wanted to emphasize, and this is something the commission fought for, is to put into the preface language, that being on probation, parole, mandatory supervision, PRCS, isn't just because you're on those things doesn't mean that you have a connection to criminal activity.
Mm-hmm.
Look, because the bottom line is people, the citizenry of and I think anywhere, they want probation searches to be used in the right way, right? But the scary story you hear is you don't want a traffic stop to turn into officers rousting someone, and you hear the bad story, but you don't always hear the good story. And you have to recognize, us as commissioners have to recognize, hey, look, it can be used, like probation searches aren't bad. There's a reason why there are probation searches.
Mm-hmm.
The district attorney in every county, or federal prosecutor in each district, puts these search conditions on cases. Now, what we think happens is, and our information is that just sort of, not necessarily blindly, but at least in the surrounding counties, the district attorney is applying search conditions in every felony case. Okay? You would think that there's some picking and choosing of, okay, well, this is a gun case, or this is a case with violence, or this is a case with this, that there would be some choice over when you put in a search clause or when you don't, but there's not. It's just blanketly put in there. On the federal side, same thing. On the federal side, there's no choice. So therefore, the prosecutors are then pushing that down to the officer level, and then it's not fair, because the officer just sees a search condition and you think, okay, well, this must be a violent case or some other kind of case, but it's not. And so that's the inequity that's happening, is that at the prosecution level, they're just saying, well, look, it's great for every defendant to have a search condition, even if you're a misdemeanor vandalism and because you got a spray can, and suddenly you're pleading to a misdemeanor with a 1035 search condition. Like that's not okay. And that's what we wanted to recognize was, look, the prosecutors aren't necessarily doing what we felt they should be doing by sort of vetting who's on a search condition. And so that's why we needed to break up what type of search condition it was, in terms of, was it a violent offense, a non-violent offense, misdemeanor, felony? Those things all make sense, because No one has a problem if someone is on a gun, is a felon in possession of a weapon with a search condition, and an officer searches them upon contact. No one's got a problem with that scenario, right? Because there's a history there. You've had a gun. And you should be able, as a law enforcement officer, you should be able to use a search condition to determine, like, hey, you've been, you've had a weapons charge, or you've had this, or you've had that. What we wanted to eliminate was, hey, there's a group of young adults, young black males on the corner, and a cop goes up and says, hey, I know you, pockets empty, empty your pockets, or turn around. Like, those are the situations. Or a traffic stop, somebody blows a stop sign or rolls through it, which happens everywhere, and then suddenly, okay, that's turning in, you pull them over, you make contact, and suddenly, oh yeah, you're on probation. So I'm going to turn this, you rolled through a stop sign, into, now I've got 4 squad cars out there, and now it's a major search of your vehicle. Like, those are the kinds of situations. We wanted it to be used in the right way all the time, and there were things we thought we could carve out which would make our policy better. So that's the overall goal, and our police department was behind that, 100% behind sort of using it in the right situations and giving up, so to speak, on sort of these lesser situations, because those are situations they don't want to be involved in either. They don't want a traffic stop to turn into a thing. I mean, that was just sort of bad for public optics, right? And so then what we then turn that into is, so then it's not okay to ask someone, particularly in Oakland, young black males, right? Hey, are you on probation? Like, that can't be the first question you ask anybody. That's demeaning, and it already implies, I think you're a criminal. And that is part of what we needed to address in this policy was, and these are some of the things that weren't in the original policy. And because it's a real opportunity, not just to talk about.
I'm sorry, what do you mean weren't in which original policy?
So the original version that we received from OPD that we then got involved with didn't have these things, because what you're really talking about is public optics. You're talking about an ability to sell this policy, to tell the public, this is a good policy, and here's why. Because look, officers can't walk up and say, hey, are you on parole? Are you on probation? Are you on this? Are you on that? Also in our policy, you can't, and this is I wanted to come to this at the end, but I'm going to come to it now. The biggest issue that you're going to find in doing this is, what does an officer need to know in order to search you under probation policy? And let me give you an example of that. I search a kid, who's on a gun charge last month, and I come into contact with him today. Is it okay for me to know, hey, I searched you, last month on a probation search clause. I'm get against the wall. I'm going to search you again today because I found you, doing loitering. That, in our estimation, was not okay. So we tried to put a time frame on it because, and we brought in sort of help from the public defender's office. Braden Woods, who's the Alameda County public defender, came, and I worked with him very closely on this policy. And, it was his information and his research that, a lot of times, someone can roll off of probation and you won't know. And then sometimes you just make mistakes. And we were trying to have it be as mistake-free as possible. So our initial version of the policy was that every officer in every contact had to contemporaneously check if someone was on probation or parole. Meaning, I searched this individual last month. Okay, even though I searched him last month or even last week, I need to run him through the system again, whether it be CLETS or any of the other systems, and check. And then the OPD pushed back, and frankly, and I think they were right to, and they said, look, that's just not how it works. Like in real policing, you don't have the ability always to do the real-time check. It's not immediate. And then also, they also do other types of pre-clearance of searches, working with the probation department, where they'll check on a certain date, and then a couple days later they'll do a search. And so there was a law enforcement procedure there that we learned about that necessitated a sort of longer period than contemporaneous. And that's the big difference between the two drafts. If you look
the
and
time
see,
frame, yeah.
it's the time frame.
Right.
So, and I will tell you that. So I'm the one that proposed 72 hours. I still don't know, and I said it in an open session in the commission meeting. I still don't know that 72 hours is the appropriate time frame. I don't know what the appropriate time frame is, but it's not contemporaneous, and it's probably not 24 hours, because if you search an individual the day before, you should probably be able to search them the next day if you come into contact with them and there's something going on.
But this is about the particular circumstance where the officer happens to know that the person's been on probation or is on probation.
Or provided information that he is on probation. How new is that information? Like,
on the records check?
For example, you can't rely on information that, like, if another officer tells you,
right.
That
Right.
individual's on probation. Oh, okay. When did you check? That is ultimately that's ultimately the issue. When did that information? When was that information double checked against the database? Not to say that the database won't have mistakes, because it might, but that is as good of a clearance as we can get on this issue.
But in most cases, is it true that in most cases, when you stop someone, it's not about knowing ahead of time that they're on probation? What about the records check that you have to do during the stop?
Well, then that's fine, because you're doing the check contemporaneously, and you'll find out that someone's on searchable probation
so these
or
are
parole.
Times you're talking about when somebody already knows.
It is because it is the real tension between having an effective law enforcement agency to know, look, I know these individuals and they're on searchable probation, and I should be able to search them. And that's if there is a legitimate law enforcement interest in that, that's true. But when was that information last checked? And that was the big question, because our information from the Alameda County courts is there are mistakes being made in terms of someone isn't on probation, gets searched by an officer thinking that they're on probation, and then suddenly, so the search is, has doesn't have a legitimate origin. But the problem is, in the courts, I mean, that search may still be valid. It literally may still be valid, depending on other factors involved.
So you're talking now about probation searches, not parole searches.
I'm really talking about all searches: probation, parole. We put them together: probation, parole, mandatory supervision, and PRCS.
Right, but the parole searches, aren't the parole searches imposed when the person comes out of prison, put on parole?
Yes.
So that's not you were talking about the DA imposing.
Yeah, but for our purposes, it's the same.
Okay.
In terms of, hey, I come into contact with an individual, I know you're on some type of searchable release. Probation, parole, PRCS, mandatory suit, right? I know, like last year, like, where's the limit? Where do you draw the line? Is it okay to say, hey, I remember you 2 years ago, I searched you. You were on probation.
Right.
I'm going to search you again. Is that reasonable? It's not, right? 2 years is not. But what is that time frame that then makes it reasonable? And that's what we ultimately debated and could not agree on.
Right. Now, did you consult get legal advice on this in terms of how this is consistent with state law and case law?
So the city attorney didn't have a role in the negotiation of this. I myself am a lawyer. The public defenders, obviously, Mr. Woods is a lawyer. There are lawyers on the other side for OPOA. So we're all, I think everyone involved is legally minded, but in terms of whether to say that we as a law enforcement body are not going to implement or we are going to curb the way we search in probation in situations where we come in contact with probationers or parolees is it's not a legal issue. It's just saying, hey, look, this is the way we're going to respect citizens. This is the way we're going to treat people with respect. They are people. They are not criminal defendants from the outset. We are not going to ask those questions.
Mhm.
It's more of a code of conduct than it is a
Mhm.
legal document. And so
Mhm.
I don't, as a lawyer, I don't see legal issues within because of that context.
So focusing on the inquiry, when you stop, when a person is stopped, and your policy says, and I believe the OPD policy also said that.
So let me correct, sorry, Kitty,
Yeah.
just let me correct you. There's just one policy. So.
Right,
so
right, but
there's
I meant the
just-
draft,
Yeah,
the
but-
original draft.
But
But
yeah,
we're only-
there's just,
Yeah,
Right.
we
one.
are, this, there's no more, look, debate is a
Mhm.
natural thing for me as a lawyer. I talked to the chief about this, and you debate an issue, you look at things from different sides to get to the best possible result. And so it actually hurts us to keep talking about this draft and that
Okay.
draft.
Right.
We have agreed, the parties, the OPD is committed to implementing
Right.
this policy. We are 100% behind this policy, as
Good.
is our city. And the chief has gone out and talked already on panels and such
Oh,
about
good.
this policy. So there's not a
Yeah, okay.
tension anymore
Okay.
unless we create one.
Good, but my question was, so with regard to inquiring about supervised release status, the policy says, inquiring at the beginning of an interaction is unjust. Such an immediate inquiry is viewed by the community as an improper assumption, etc. To that end, officers shall not immediately inquire whether an individual is on supervised release unless there is an immediate threat to officer safety or the safety of others. Subsequent inquiries should be respectful and so forth. Can we talk about specifics of when, at what point and under what circumstances the inquiry would be
Sure.
justified?
This is a really easy one for us because, look, I'm Japanese and white. I drive a fancy car. No one's gonna pull me over and say, "Hey, are you on probation?" The first question.
Mhm.
But if I were black and and I was driving a different kind of car and I get pulled over, it may be that I get that question. The fact of the matter is that this is about correcting racial inequities, and that our officers need to improve that situation. Frankly, this is about treating people with respect, all people.
Mhm.
And so you just can't ask the question to anybody,
Right.
just across the board, because it assumes, using my hypothetical, it assumes a level of, hey, you are a criminal defendant, or possible, or you have a criminal record, or you've been involved in
Mhm.
criminal activities previously,
Mhm.
right? And so that's the issue. And so it's okay to ask that eventually, and that's why we define it as immediate threat. And that's, that's defined in our DGOs, our Department General Orders. And so once that interaction elevates to a potential threat to the officer or the public, then at that point it's appropriate to ask the question.
And so, yeah, I think we're all on board with what you're saying there. We've been discussing about specifics of that, like how does the officer, what circumstances would prompt when you say safety of the officer and so forth? That's already discussed as triggering an inquiry. I'm wondering how this is different. Like, what level of threat would
Yeah.
prompt? How can we make the policy specific so that it's no longer sort of open-ended?
So all I can point you to is our DGO for immediate threat, which is I want to say it's like a 4 or 5 page document
Oh.
upon how threats are defined.
I see.
And so once
Do we have
something becomes a threat, I'm sure you have a version of
Use of force policy.
Yeah, you have a version of what a threat
would-
is, right?
Go under the use of force?
But once you have something become a threat, then look, the two most important things to keep in mind, even in the face of this policy, are that officer safety and the safety of the public are the two most.
Right.
They're the two most important things, and so you want to try to create this policy without impinging on those two items.
Right.
And so you can walk up to that line, but once you cross that line, it becomes an immediate threat as defined elsewhere by our DGO. then it's then it's sort of, look, hey, look, do it respectfully, do it politely, but once it becomes a threat, it's a threat, and
I guess I'm struggling with imagining, and you all can help us here, but I'm struggling with imagining an immediate threat being assuaged by asking the person if they're on parole. How does that de-escalate this? If there's an immediate threat, and I'm thinking it looks like somebody's going to pull a gun or something, how is that assuaged by asking that question? I'm trying to envision this. I mean, seriously, I'm trying to figure out how the inquiry can help the situation if it seems like that person's dangerous.
Well, you brought this up last time, and it seemed like you wanted, very specific situations that we encounter, and I gave you a couple off the top of my head, but I think the policy, like all policies, is meant to be a guideline, and it can't account for every single thing that happens. Off the top of my head, what I'm thinking right now is you stop a car, and as you're stopping the car, people are reaching under seats or stuffing things in the seats.
Right, I understand. I can visualize the threat. I just can't imagine how asking the question somehow de-escalates it.
So I'm trying to explain.
Okay.
So if in that moment when you walk up to the car and you can't see where that person was reaching, there's multiple people in the car, one thing you might use as a tactic, if you cannot see a gun and you can't detain everybody immediately, is to ask if anybody in the car is on probation or parole. Now what that would allow you to do is then determine if people are reaching under seats and somebody in there is on probation or parole, then that allows, as a safety issue, for you to then secure the people in the car, or to make sure that no firearms or anything are hidden in the car. That's just off the top of my head. If the idea that you can have a policy that spells out every single incident that happens in the
And have you seen this work for you in terms of
Yes.
de-escalating a threat?
Yes. And oftentimes, in that situation, when you're walking up to a car, that's probably one of the most dangerous things that we deal with.
Mm-hmm.
And I have encountered and detained dozens and dozens of people who are armed with firearms in cars.
Mm-hmm.
And that is one of the ways that we have done that without it turning into an officer getting shot or us shooting somebody else.
Mm-hmm. Okay, I probably interrupted you with, I just have so many questions.
I'm trying to pull up the DGO right now, and I can't. The signal's not good here.
And so do you know if we have a policy on the books about what constitutes an immediate threat?
It would be within
Under
our
the
use
use
of
of-
force policy that explains what threats are, what an immediate threat is.
Mhm. This committee should probably, we're gonna have a use of force committee too. Seems like maybe they should be.
Can I make a suggestion?
Yeah.
I appreciate that sort of context and that hypothetical. I think that there are so many things that you can't necessarily anticipate that go into that. Like, it's not just the one act of reaching under a car. It's like time of day, where neighborhood, like, what are the other people in the car doing, or people fidgety, what do their eyes look like? Like, there's so many things that go into that consideration, right, that I don't think that we can necessarily anticipate, like, okay, in this situation it's okay, but in this it's not. And that's why imminent threat to officer or public is used. That's why we use that. That is, look, you have to eliminate where you can the subjective in the policy.
Right.
But that's one instance where you cannot. You have to.
Mhm.
It's too much. It impinges on officer and public safety too much to be too heavy-handed. Now, on the flip side of that, we say in our policy that traffic stops you cannot ask in a traffic stop, because the purpose for the stop is it's a vehicle infraction, right? If the purpose for the stop is a vehicle infraction, unless it escalates, it's an infraction. There's not felonious criminal activity being proffered. So as long as it stays in the world of an infraction, right, you can't ask at all.
Well, except unless there's a perceived threat.
Now, right, if it escalates to threat,
Right.
based on the totality of the circumstances,
Right.
then, but unfortunately, that is where sort of the line gets blurred between, like, look, we want the best policy we can have, but we cannot,
Right.
we cannot affect officer safety,
Right.
or public safety.
Right.
So that's the hard part, yeah.
Yeah, sorry. So on the, in your description of this, there were several issues that I'm not clear on.
Yeah.
So are you saying that on a traffic stop, if we agree that officers should not systematically walk up to cars, ask for a driver's license, and ask people if they're on probation or parole, that is inherently offensive to certain people, or we are not fighting on that. The question is, on a traffic stop, if the officer doesn't ask, they run a records check, person comes back on probation or parole, are you saying that in no circumstances would the officer then be able to conduct a search?
Unless there is something else for, well, that's where the type of offense that they're on probation parole for would kick in, right? There's a difference in our policy between nonviolent offenses, and so that's our line, nonviolent and violent, and we clearly spell out things like, here, I'll just read it straight out of the policy. Offenses using the use of force, threat of force, use or possession of a weapon, sexual violations against the person of another, human trafficking, the use of force or threat to public safety, battery on a police officer, reckless evasion of a vehicle, or a violent felony is defined in Penal Code 667.5C. Are violent crimes, weapons, sex offenses, or crimes involving threats to public safety. Those we together, us and OPD, we pulled out the penal code because frankly, we wanted to make that as expansive as we could, because in our mind, those things are like, if you come into contact with an individual on probation or parole for an offense like that, and there's a need to search, then search. But everything else, your misdemeanors, right? Your DUI misdemeanors, your petty offenses, even your what I'd sort of consider sort of light felonies, right? Like those are things that you need to search for. You would need to search for, and that's where we ended up drawing the line. Your line may be in a different place.
That's a pretty strict line, because I mean, one of the biggest problems, we don't have a lot of violent crime in the city of Berkeley, but we have a ton of property crime. So between auto burglaries, residential and commercial burglaries, organized retail theft.
Yeah.
So, I mean, they're killing us at Lululemon, at the iPhones, or the Apple Store.
So let me give you a example. This is where I think the rubber meets the road for you folks. Is that so? If you have, a lot of times you'll see coming to the courts like an auto burg case, right? And the DA will let someone plead to like possession of burglary tools or something, right? It's like a lesser included, and so you get that, and so you don't get the big felony, but you get something else. And in our mind, like that's not that doesn't trigger sort of the search.
That's the biggest problem I have with it, is that we know that people who do stick up armed robberies with guns plead to grand theft. And that wouldn't be on your list of somebody whose conduct that was pled down to this lesser not included in the policy offense. I mean, it would mean that we're not monitoring a type of harm or a type of victimization that person has participated in.
So the argument against that is then, okay, look, it's not saying you can't ever search that individual, because you can. If that individual, if there is belief that there's criminal activity afoot, you don't need the probation and parole search to search that person. You get to search that person because they're involved in the totality of the circumstances, which indicates that a search should be triggered. This is a case where that person isn't. Don't shake your head just yet. This is a situation where that person isn't involved in criminal activity. You don't have a connection to a nexus of criminal activity. You just have a person who's, I'm just on probation, and I'm not. You've made contact with me, and I'm not doing anything. And so you're saying, hey, look, I benefited because my lawyer was good and got a reduction from one charge to another. So you're going to say you should still be able to search me even though I'm not doing anything, right? That's the question. If I'm doing something that's connected to criminal activity, you don't need this. This is just a catch-all.
That's the condition of probation in and of itself, is that people have agreed to submit to warrantless searches.
Yes, they have. But as a city, as a department, what you're saying is, we're gonna treat our citizens better, right? We're gonna go out and we're gonna improve the way we service our citizenry here by saying, look, we're not gonna go out and ask people, hey, are you on probation or parole? We're not gonna go out and search people who aren't connected to criminal activity. We're gonna do and we're gonna be better at what we do. And the relationship between the police department and the public is gonna be better for it.
Asking is one thing. Saying that people who have basically taken a deal to avoid incarceration with the agreement, because they can avoid probation or parole by serving their sentence, correct?
I mean, I don't think that happens a lot. I
No,
think
it
that
doesn't.
I think that I'm a criminal defense attorney, so I
And so
for
you
20
understand,
years.
I know, so you understand
Yeah.
that people take deals because they want to serve their sentence in the community. And as part of that deal, they agree to certain stipulations. And so now we're saying, you know what? You may have committed this crime and you have agreed to a warrantless search, but now we're not even going to search you at all. So it's just, I mean, honestly,
It's
there are
tantamount
people.
to a probable cause search. You would already have reason to search. In so many cases, probation covers the gap between reasonable suspicion to detain and probable cause search.
Right.
It opens
So,
warrantless search.
so here's guys. This is where this is just one of those moments. Like, as a department, you either want to do it or you don't. Like, our department, OPD, wanted to do it, right? They wrote most of this policy. It needed to be tweaked and corrected and made better, but they wanted that. It wasn't just for them about, hey, we won't ask you first. We actually put that in later, right? For them, it was, let's figure out in what situations we can carve out searches, right? Because we want to be able to do it better. And that this in their mind was that. Look, if you don't want to do it, like, that's between you and your police commission, right? I can't make a department want to do it, nor am I here to. I'm just here to explain, here's our policy, here was the thought behind it, here are the arguments on both sides, because I get it. Like, I absolutely get it. But what I don't hear you arguing for is officer safety. And you should be arguing officer safety, not, hey, look, we need to, these people, these individuals, and again, let's talk about who we're talking about. We're talking about black males. These black males agreed to be on probation, so that's probable cause. We should search them. Like, that's kind of not okay, man.
That's not what I.
No.
That wasn't said here today.
No, but that's, your argument is tantamount to that. That's literally what we're saying when we're, because if you're not saying, I'm searching
that's not
them.
my argument at all, and I would. I
Then please.
appreciate you
I would-
sort of having a lot of history here,
I
but
would-
you don't have a lot with me.
Well, I would offer you the opportunity to correct what you said. Then please say what you meant, because that's the way I took it, and you know.
So regardless of race.
But you can't take race out of the equation. Being on probation is really about race, right? What are the
Yes.
percentages of people
It
that get
is.
searched on probation? Do you know your numbers? Do
We don't.
you know them?
I don't think we collect the statistics
So-
by race.
Are they predominantly black? The people you search on probation,
90%
on
of them
probation
probably.
searches, are they predominantly black?
We don't know.
Probably.
We don't have that.
We do know.
We have the,
Stop date.
They're not
we
black.
have,
Stop
we have
data.
stop data,
Black.
but we don't have
Identified.
that, but I don't think we have the
We
search
do have
data
The
by
stop,
race,
the
do
stop
we?
data identified a huge
No,
disparity.
the stop data,
Yes.
but the
that's-
searchate, yeah,
Disproportionately.
Stop
probation
first, then the
searches.
search comes second.
yeah.
But the stop data over the last 4 or 5 years is searches of people of color are 2 to 1 to people of, Caucasian or white.
The stop data?
Yeah.
Oh, I thought it was more than that. I thought it was like 4.5 to 1.
On the searches?
Oh, I thought you said the stop
I'm
data.
talking about searches.
Yeah, so actually, I think the search is 4.5 to
Maybe
1.
higher
There's
than
two
that.
In any
different
case,
things.
let's not get bogged down here, but I do have a question about the not searching for nonviolent offenses. So when you have the situation that they're describing, where the officer feels that safety is concerned, the guy's reaching under for something, maybe it's a gun, And that triggers the question, are you on probation or parole? And they say yes, but you find out that it's for a nonviolent offense. I'm thinking about the nonviolent probation
So
status.
can I give you a better hypo for C3? So C3 is meant, and the language of C3, if you don't have it in front of you. So when officers contact an individual on supervised release for a nonviolent offense during a traffic stop for any infraction, and then there are no articulable facts present which demonstrate that the individual is connected in some way to criminal activity, or the individual isn't an imminent threat to officer or citizen safety, officer shall not search that individual or his vehicle pursuant to the supervised release clause. So what that is you pull someone over, take their license, you know, it's whatever the traffic infraction is. You take their license, you go back to the squad car, you check, you're like, okay, this person is on searchable probation. Go back to the car. He's done nothing to indicate that he's involved in criminal activity. You don't pull him out of the car and search his car.
Yeah, so
You write him a ticket, and you say thank you, sir, and you send him on his way. That's the way that should happen.
It was my mistake. I didn't see the
Oh.
imminent threat clause here. Okay, that answers it. Another question I have is, where does this policy get inserted in the Oakland manual? Is it under traffic stops? Is it under, what does it come under? Do you know where it's being inserted?
It's
You
a
mean
standalone
it's a
policy.
What?
stand-
It's a
Standalone?
Yeah, it's a
It's general
it's a
order,
DGO
right?
for us. So
Okay.
we have just a whole list of DGOs.
Okay. What has been your biggest challenge?
Timing. I think I think that I had said in the beginning that I was sort of kind of pulling the conclusion early, but these sort of issues we didn't really get pushback on because our department was
They initiated it.
interested in carving out situations where they could, you know, implement a policy where they wouldn't search. The big question is timing, because in essence you're saying, look, I want officers to check every time, which was our position.
Mm-hmm.
They wanted to be able to rely on information they had or past history with an
Mhm.
individual.
Mm-hmm.
And so that needed to be, we needed to put a date on it.
Right.
And so ultimately, we went with 72 hours. And
Were
that
they
was-
pressured to initiate this by the, what do you
Monitor.
call it? The way?
Consent
The
decree?
monitor.
The monitor,
You
yeah.
know, not that I'm aware of specifically, that the
Mhm.
monitor said, hey, look, you need to have this type of policy. Look, there's no, and I get the difficulty in this policy. This is the only policy in the country like this,
Mhm.
right? And what you folks are considering is, I mean, really, it's new ground. Like
Well,
there-
California is one of the few states that actually has these open searches for parole and probation.
It is what you are. It's going to be. It was. Look, this didn't happen in a month. This took a
Right.
year for us, and there was a lot of this. There was a lot of back and forth. And I'm used to
Mhm.
this, and then so I can completely respect your position and still debate with you on it. And so
I just want to make sure it wasn't mischaracterized.
I do
my
want
question.
you to have the opportunity to
For the
clarify.
record, we know you.
I do want you to clarify what you meant, because I don't want there to be a mistake, because I do want to have lively debate about this, because you're going to need to debate this,
Mhm.
and you're going to need, because there are competing concerns that need to be addressed. But ultimately, OPD wanted to do it, and so what we came down, where we, I think, were really helpful is we were able to add in language to make this about the individual, to say to individuals, hey, look, you're not, you are not a criminal just because you're on probation, right? You're not involved in criminal activity, I should say, just because you're on probation. You're on probation. It's rehabilitative.
Well, I guess the question would be, do you know the numbers of how many people on probation violate their probation? I mean, you're saying that people are in Alameda County. You're saying that people who are on probation are not involved in criminal activity. We know that's not true. You can't make a blanket statement to say that. I mean, we have tons of situations where people who are on probation are actively involved in criminal activity.
But not everyone is involved in criminal
Oh, I
activity.
agree.
So you can't go search, So the whole idea is don't go search everybody. Search only those who are involved in criminal activity. Can you get better at it?
But your idea is to
Can-
just
can you
don't
move the
search
legal
anybody.
line?
Don't search anybody on probation or parole.
But that's not what this says.
That's not what it says. You gotta read it.
It
I
says
guess I have a
if they're
question
on
about-
probation or parole for a violent offense, and I
understand.
understand about the bargaining and so
The
forth. Or-
nonviolent distinction is very problematic. I mean, we know that people who are involved in, who are convicted or on probation or parole for nonviolent offenses are also, in many cases, and still involved, actively involved. All of our burglars, people who are still running around here stealing bikes, going into stores, committing low-level criminal activity, they're on probation or parole, and we're basically saying that we are not going to hold them accountable, not going to try to see if they have burglary tools on them, not going to see if they're actively involved in criminal activity.
So, and just so I can put a finer point on it, you see an individual riding a bike, you know, because 3 months ago you busted him for burglary, and so you think that because you see him, that he's probably on probation or parole, so you stop him on the bike, and then without involvement in criminal activity, you see him and you stop him, and then you determine that he is in fact on probation, right? Because he's pled to something, and then that's an investigative tool for Berkeley PD. Then you would search him at that point. Is that a fair?
Sure.
Okay. So that's the situation that we try to eliminate, right? And that's where again the tension comes in, is because I hear you say that's an investigative tool for us. We were just faced with different issues because, look, for us, it's about improving community relations. It's about race relations. It's about getting rid of, racial discrimination, within the way we police. I mean, we're just fighting different issues, maybe, and I can't address that within our policy. Maybe we just got bigger problems. I don't know, because I'm not going to tell you how to do your job or you shouldn't do it, and I recognize the fact that that's one of your tools and you use it that way. So
And it's a tool that we use to reduce victimization. It's a tool that we don't want people to feel unsafe in their homes because they've been burglarized. Keeping track of probation and probationers who have committed burglaries is important in this community to make people feel safe in their own homes. That I'm not advocating, conversely, for bias or any systemic issues. As a matter of making that important statement, we should be able to do that work without impacting negatively people based on bias. We should be able to make our community safe without damaging our relationship with the community.
Yeah. One concern Berkeley has, you stated earlier, by not getting the policy out to the community. Berkeley has in General Order B4, which was passed because of profiling in this community, and because of the data that was gathered that demonstrated the profiling was going on. So we created General Order B4 to create a situation where we could hold officers accountable, but it was also depending on the data, correct?
Right.
That was being collected.
yeah.
It's never happened. We still don't know what officer are stopping whom in what area of the city and why, but we still are living with the disproportionality of the stops, and that just has to stop. I mean, it's more, as you know, connected to a person being stopped. That person might be on a business, on his way to school, on his way to work, on his way to whatever, and you're stopping them and holding them up, and they miss out on opportunities. I've seen too many times in South Berkeley where individuals are stopped. The officer have everyone in the car get out the car, sit on curbs, and then everybody ride away and nothing happens. I just don't understand how that could happen. I've always wondered, if there's an infraction, because I'm watching to see if a ticket's going to be given to anyone. No tickets are given. People ride away. The chief stated in a meeting that, well, do you want us to give everyone a ticket? If they committed an infraction, they should get a ticket, perhaps. But just to stop people to see who they are, where they're going, what's in their car, that's preposterous, and it is racist. It's done primarily on racial lines. See very few Caucasian people being stopped in South Berkeley that have to get out their car or go through some kind of body search. So we have to get some kind of tool in place that will help us minimize at some point
Yeah.
these kind of
So let
actions.
me speak to sort of you folks at this end of the table for a minute. So part of what I think, and I agree with you 100%, like, and unfortunately no department in the country is going to say, yes, we racially profile, right? No one's going to do that, you know, but until you recognize the issue, you can't create the solution, right? And that's a big part of it. But you've got to decide what is important in this policy for you, because you're not going to get everything, right? You're not going to get the perfect policy. So you have to create the policy that is progress, that also OPD can live with, that you can jointly take to the public and say, this is a step in the right direction. Now I hear them talking about burglaries, like maybe I carve that out. Maybe I say, okay, well, because our issue was violence. There's violence and guns, right?
Mhm.
So that's our carve out. Maybe burglary is your carve out because
Well,
you don't have
guns
a lot
are
of
a problem,
right?
too.
So,
Yeah.
but looking at those issues and figuring out, like, okay, what are our issues? Because your issues aren't our issues. Like, good policing is everybody's issue, right?
Mhm.
We got to have better policing. I mean, across the board. That's just that's not a criticism of anybody. That's just across the board. We got to have it, and we can always do it better. Like, we as a commission can do it better. You know, the police department can do it better, and the whole ways, just because they work doesn't mean they're the right ways. You know, a lot of times now, like, we got to demand that police departments get better at what they do, and it can't just be, okay, like, this is our investigative tool, so we're going to use it. Okay, well, that worked, but in this new day and age, to combat racial profiling, we've got to change the way we do it. We have to change the way we police, and that's hard to do in an institutional, you know, in an organization like the police department. And so figuring out how you want this policy to read, what you want in it, I mean, is really going to be, I mean, that's going to be the
Yeah.
topic of much discussion for you folks. It's not going to happen
So
overnight.
so the city commissioned a study and a report by the Center for Policing Equity. And what they came up with, looking at, drawing from the department statistics and so forth, they came up with two things. One is that Berkeley does better on looking at the disparate statistics than most other cities of its size, but that there were still great disparities in terms of who's stopped, who's searched, who's, you know, at each step of the way. So it is true that Berkeley does better. The Berkeley department does better than most departments across the country in terms of racial disparities. But they remain entrenched. And there were criticisms of the report. One of the criticism has to do with, you know, these, I think it was 4.5 to 1, 4.5 to 1 in terms of blacks being searched as opposed to whites. Given the demographics of Berkeley. So one criticism was we don't know where the people who were being stopped resided. You know, they might reside in Oakland and get stopped here, and that would skew the statistics. But whatever criticisms there were of the statistics, it probably is the case that some disparity remained. You know, and so that partly triggers, you know, partly is the impetus behind the commission's decision to launch this. We actually decided to do this. We had our first committee meeting, and exactly, I think it was the same day it came out in the papers that Oakland had passed a similar kind of policy. So we were already on this road, and then we saw that you all had done it, and we were really interested to see how, you know, what the thought. I mean, we understood that the department had initiated it, but was there a great deal of community involvement or not?
I mean, there's some. The problem is folks on probation and parole aren't necessarily a vocal minority, right?
Uh-huh.
You're going to come to meetings and such.
Right.
And when you really think about it, I mean, this is a policy that really affects low-income people of color,
Mhm.
right? And so that's also not a vocal minority. That there are people, I think, who are in support of this for good, in terms of good policing. But this is the citizens that are affected by this, and you're right, aren't necessarily Berkeley citizens, right, or Oakland citizens. They're going to be people passing through our cities.
Right.
And how do we deal with that? And that's also a big topic of debate. But you're not going to get a lot of public support for it, because frankly, at the end of the day, you're doing this because it's the right thing to do, not because you're going to get a lot of noise.
Right.
But of course, you said several times that the OPD was pushing this. What pushback are you getting back from the union?
You know, I'm not privy to those conversations, so I don't know.
Because there's a big difference between the administration of the police department
Mhm.
and the union, right?
Yes.
So I would like to know if the union had very serious concerns in what's happening in the meeting. For obviously that's behind closed doors, but I don't know that it is that it's fair to say that the police department, right, the rank and file, that everybody in the police department is supportive of the policy.
Yeah,
Right.
we don't have any way, and those meet and confer processes, we know that from the charter amendment, meet and confer that's going on as we speak. They're really closed doors.
So I think will learn what criticisms they may have of the policy by any changes or tweaks that happen to the policy after that time is up. So
Okay.
But you don't have any sense that it will be substantially changed, or you can't know?
all I have is the chief's commitment to
Mhm.
this policy, command staff's commitment to this policy, and the implementation plans that have already
Mhm.
been put in place. So there's not a thought that this gets scrapped because of
Mhm.
the union's meet and confer. So
And just quickly, I know, one thing that we always talk about here is, within the PD is that we would like to be judged based on the track record at BPD.
Mhm.
And, obviously there's some concerning issues with the study, with the disparity in stops.
Mhm.
And, clearly we've started to address that, implicit bias training, racial profile training, and the supervision that we're doing on the street to make sure that we're addressing any of those disparities, and then wearing body cams, all those things that will help to create more transparency. And so it seems to me, with the PRC, between PRC and IA, that if this was a problem in Berkeley, improper searches of people on probation and parole, that we would have some evidence of that, right? Like we should have complaints.
They wouldn't.
You know what we have evidence of, actually? We have evidence, and I can't give you, we have some evidence that people are afraid to come forward,
Okay.
I have to say.
I'll just finish my thought. If we should have, if we have a systemic issue within BPD,
Mhm.
we should see sustained complaints. We should see some evidence that that is happening. We have body cams. We should be able to point to a complaint, say this officer stopped me and
Yeah.
searched me improperly, and pull up the body cam
And-
and be able to see that.
And now
right?
that those body cams are on, it's only been for the last year or so, right, that we've had everybody wearing body cams. It might change things a bit. I don't know. We
But
have
why,
yet to see.
why would you complain though? If I'm a probationer
That-
and I
they're
agree
reluctant.
to your point that hey, I have a search clause, and the officer tells me you have a search clause, I'm searching you, right? And I'm not involved in any criminal activity or anything else, and I don't feel like my rights have been violated. I gave away my rights at sentencing because I agreed to the search clause. What do I complain about? I complain about an officer being rude to me. So the answer to the question is go to Braden Woods, the public defender in Alameda County. He will tell you because he told us. Not necessarily numbers of cases, but examples of cases involving maybe improper use of searches, factual-based analysis of those searches in Oakland. He could probably do the same for you in Berkeley.
And if that's
What
the
we
case,
do hear complaints about is people being asked the question.
Right.
right.
I mean,
So we've never been far apart on the issues surrounding the questions.
okay,
So, you know,
well, we're gonna
really-
talk about in the
yeah,
second half here.
We're really close
Yeah.
on that.
Yeah.
We've always been further apart on
I
feeling
know.
like this organization for this community
The
to go
search.
as far as Oakland went
Yeah,
on whether or not to search.
yeah,
And we already have policies to discipline officers for improper detention, improper searches, abuse of discretion. You know, we have ways to deal with that. And just to make a point, I think you said that when officers conduct an improper search and then the case goes forward, that somehow that evidence may still be presented. I mean, that's going to be thrown out.
That's not true.
It,
If I do something improper and then the car gets towed, then, you know, court will say, well, on the inventory search, when the car gets towed, I would have found it anyway. There are lots of ways that courts will find harmless error and keep the search in. So you can't, I don't think we can say generally that if it's a bad search, it will always get thrown out. There are lots of bad searches that find a legal loophole to get through. To your point, though, I agree. You know, every department has ways to discipline officers who violate rules. The problem is this isn't a rule. This is about equity. This is about treating people with respect and the right way. And I gotta tell you, officer, I don't mean to say that you or anyone in your department doesn't treat people with respect. I don't know. You know, I only know my city. And I'm only going on generalities here. But if you've got a 4-to-1 African American, you know, stop issue, which is if those are where your number's at, okay, then this is an issue that disproportionately affects African Americans. It affects likely young black males. And so, what are we doing to change that? What transformative changes do you want to make? And if the answer is we don't want to make any, then okay. But if you're interested in making them, obviously not asking the questions and, you know, is the right stuff, but what can you carve out to say, okay, look, we want steps in the right direction because we get that this will improve our relations with people. This will make us a better police force while still maintaining our ability to investigate crime, protect officer safety, public safety.
but we don't know that because, I mean, I can show you volumes of cases where officers have made arrests for people who are involved in ongoing crimes, ongoing criminal activity, or on probation or parole or PRCS. And the reason the officers were able to determine that they were involved in criminal activity right now is because they used their search clause.
And I agree with you, but I think the key phrase you said there was involved in ongoing crime. There's nothing that in our policy that would stop an officer from searching someone who's involved in ongoing crime.
But that's
It
the
is-
mechanism for the discovery.
It's
of
the
Probable cause
it's
search.
the traffic stop. We don't want our citizenry to feel like, hey, if you get stopped, then suddenly you got, you know, you're going to be searched. If they're not involved, and maybe that's the start, if they're not involved in criminal activity at the time, but they're on probation, do you have to search them? Do you need to search them?
I guess the term involved, how do you know that a person that you stop is involved in criminal activity at that time?
That's the law enforcement and you speaking, right? Because, like, again, I don't necessarily know that if I pull over a young black male for rolling through a stop sign that he's involved in criminal activity. I would take offense that you would say that he could be or
Who said
is
it was
likely.
a young black male?
Because we're talking. This is a policy
this
about
is
young
about,
black males. And until we like recognize that part of the
Yeah,
issue,
that's what it
we're
is.
we're just not gonna get anywhere.
You're talking
Well-
about any person who's on probation or parole, Hell's Angel, whoever it is, right? So you're telling me now don't search this person, period, right? Unless we have this small card.
No, it's the other way. The carve out for not searching is very small. What I'm saying is if you pull someone over in a traffic stop, right, and they're not involved in criminal activity, right, it's a traffic stop, but they're on searchable probation or parole, you don't need to search them. Because in your hypotheticals you said we want to search people who are involved in criminal activity. This person isn't involved in criminal activity.
Well, they're saying they discover that after they search. That's
So,
the
so
difference.
search everyone.
That's the
So search,
difference.
search
That's what I
every
said,
citizen
search
everywhere.
everyone
and,
and ask
let's go to
everyone.
military
I don't think
state.
we're gonna get anywhere
Yeah.
with this.
Okay.
But
So
I
he's a
actually
defense
think,
attorney.
what we.
No, well, don't hold that.
Right,
I'm not holding
right.
law
I mean,
enforcement
it would
against
be
you.
odd.
Come on.
Sounds like-
Yeah.
It would be
No,
odd if
I'm
you
not.
didn't
I do.
disagree, would it?
Can I
Hey,
ask a
hey.
question?
Yeah.
You don't know my
One
history.
quick question.
I represented cops in front of the police commission in San Francisco. I represented cops. I know both sides of this issue, right? Don't like, but again, and the folks, and sorry, sir, we didn't meet, but I assume you're from one of the legal organizations, right? And you serve from the ACLU. Until we recognize together this is an issue about race, like
It is.
we're just not going to get anywhere. But let me say this because I know you want to talk. I'll take questions. I feel like my presence at some point doesn't help you, so I will remove myself from the room. But if you have questions, I'm happy to answer them before I depart. So,
I have a quick question for you.
Yes, Michelle.
So,
Could we
you
ask
know,
the
you say you
questions
have
after we
volumes of situations where you do the search and it proves that you've discovered some criminal activity. Do you have numbers on that? Do you keep numbers on that? Searches and
Discovery.
hits, so to speak?
So we keep numbers on searches in our car stop dispos.
Right.
And anytime we book somebody who's violated the terms of their probation, we also book them for a probation or parole violation. So you can take those two data sets and extrapolate.
We don't have access to those, to
The-
these data sets. Do you read them? No? That's one of our concerns is, you know, there's been data collected on stops, and we feel like in this period that it's been made public, that the police department hasn't even read their own data.
So that's the reason why we brought in CPE, because we wanted some deeper statistical analysis. We didn't want to sort of fumble around in the data. We wanted to bring in experts
Sure.
to
It's hard
interpret
to
the data.
read raw data. I mean, it's almost
Yeah,
impossible.
and they gave us some conclusions and some warnings came along with those conclusions.
Right.
And we're trying to sort of make the most and best policy out of what we've learned from those conclusions. But what, you know, it's interesting because a lot of times the conversation will dart over to data and then it'll dart into anecdotal. And what Sergeant Fomy's talking to is we have a lot of anecdotal data. It happens every day where we come into contact someone for some relatively minor reason, discover that they're on probation or parole, serve the condition of their probation search, and then find out that they are committing crimes based on doing that. And so that, for us, we hope translates to public safety in terms of that person is not continuing to commit that crime, that they've been caught for the crime, that they're not victimizing another person tomorrow if they're going to keep going. And so that's really important to us to create, you know, to try and make this a safe community.
Well, our concern is, one of the concerns we have is that, you know, again, do you have statistics on that? But that, you know, by continuing, even the people on parole, that if you continue to treat them as criminals, they'll be criminals, and we don't let them off the mat, so to speak. So, is there any way, you know, I guess that's what we're trying to reach, that you're willing to
Right.
carve out your procedure
Right. But we'll-
to do that?
Yeah.
And that's what we're working on.
Right. I think at this point we should release the commissioner.
Can I have a card?
yeah, I'll leave.
Thank
Oh,
you
that's
so much.
wonderful. Thank you.
And thank you for having
Thank
me
you
today.
so much
You're
for
welcome.
your
Thank you.
Appreciate
presence
it.
and your.
Very informative, thank
Yeah, before
you.
you go,
Yeah.
when Berkeley did its general order before, it included pedestrians, bicycles, along with traffic stops. Because people being stopped on the street and searched, just walking the street.
Yeah.
That's another issue that's very concerning, that you guys deal with.
You know, we have, I want to say that OPD has an entire bicycle policy that I have to admit I'm not fully expert on or necessarily aware of. You know, unfortunately, like our policy doesn't go that far. You know, we talk about traffic stops. We don't talk about in that scenario, because we're talking about infractions, right? You know, I think the problem is I can create in my head 100 different hypotheticals or scenarios where there are issues, you know, with young males on a corner, you know, and what is happening, what an officer sees or doesn't see, or criminal activities or not. And I think what we wanted to eventually get to was, look, if there's evidence of involvement in potential criminal activity, that's one thing. But the fear of individuals being involved in criminal activity is not okay, and that's the difference. Because what I hear is, well, how do we police? And the answer is, you get evidence of criminal activity, not the fear of, hey, they're potentially involved in something. And that's I think the sort of big issue coming to it. So sorry, I don't have more for you, but
Thank you.
yeah.
That
No.
was
Do you have any more of these cards?
Oh, yeah, I think I do. I got some here, so.
Thank you.
Thank you so much. Oh, thank you so much.
Did you want to?
Yeah, absolutely. No, thank you for all your good work.
Thank you.
It's a pleasure to meet you. Are you
Mentor Id-Deen, I'm with the Berkeley and
Oh,
ACP.
I'm sorry.
fantastic? So you, Thomas Smith? Are you? Thomas Smith was our former chair. He's on the commission. He's a city attorney of. He's I want to say he's an officer of NWC. Not.
He's not with the Berkeley.
He's not with the Berkeley chapter. So
Probably.
All right. Gwen, it's really
Yeah.
nice to meet you. All right.
Thank you
Kitty,
so
thank
much.
you.
Thank you.
Thanks, guys. Hope it's good. All right. Yeah. Thank you. Thanks for. No. Thank you, guys. Good luck. All right. Good luck, everybody.
Thank you for coming.
Yeah,
Thanks so
appreciate
much.
it. All right.
Hope you don't meet traffic
Okay.
Tuesday after Labor Day. Bye-bye.
Bye.
Well, that was interesting.
Very.
I propose that we, is there any debriefing you want to do?
Yeah.
No, okay. I propose that we focus now for the next 45 minutes or so on the language that you brought to us and look only at, a lot of this discussion we've just had was about the search conditions and everything, but I propose that we focus now on the inquiry, the asking, are you on probation or parole, and the language that Lieutenant Montgomery brought to us.
Do you have a fresh copy? I got copies here.
Yeah, I have my marked up copy. Do you all have copies of this? Yeah,
Isn't it part of the,
it's part of the agenda packet. Did you get
Did
the,
you
you got
get
the
an
agenda
agenda?
packet, Chris?
There's copies too.
Do you have the agenda?
no, I did,
Okay.
So how
You
do
got just the first page?
how would you like?
yeah.
The second page is the, yeah, okay.
So would you like me to kind of call out the
Sure.
highlights or the high notes
Yeah.
from our discussions? So last time the commission asked if we could look at the immediately, using the term shall not immediately. So we looked at removing immediately. In the process of doing that.
Wait a minute, I'm sorry. Oh,
Which paragraph are you on?
The fourth one,
Okay,
where it says officer
gotcha.
should not
Mhm.
ask, okay?
oh, I
So-
see, right.
So prior to
Mhm.
that, it said officer shall not immediately. And
Right.
the issue was raised about, well, I'm not so sure we want immediately. So
Right,
when I was working on taking out immediately, I came up against the issue that here we're saying we should not do it, and then
Mhm.
talking about when immediately, and then giving a list of kind of situations where an officer may have a need to ask, and it may be okay, given
Mhm.
the context of the situation.
mm-hmm,
And so, and the only way to make that sort of make sense, that dynamic make sense, was to change it from shall not to should not ask.
mm-hmm,
Change it from shall not immediately
Mhm.
to should not, because that's kind of what
Mhm.
shall not immediately was covering, was the
right,
time that at some time you may need to.
right.
Also, you asked, the commission asked for certain examples of circumstances where legitimate law enforcement or investigative purpose might lead an officer to ask. And so I gave a couple examples, and we can talk about those if we haven't already.
Mhm.
Not to be an exclusive or a limited list, but just some examples of situations, because we know we can't sort of come up with and identify the long laundry list, but to give you examples. And those examples were sorting out multiple returns and common names. So for example, if I stop somebody named John Smith the computer's going to tell me a lot about potential John Smiths out there, and figuring out which John Smith is the one in front of me and making sure that we're only searching the correct John Smith is something that sometimes you have to ask questions from the person you're dealing with to clarify that they're the John Smith on probation out of Alameda County for burglary. So there's a process that has to go through, and at that point it comes down to a conversation, a clarifying conversation. Confirming the status is known to officers, so the officer knows. I like we were discussing, I ran this person out, I know they're on probation. I'm seeking them to serve a probation check on them. Okay, so that would be something you already knew, you already confirmed, you knew the person was on it. Now I'm talking to you about like just confirming you're on probation, right? And the other one, it was just kind of included, is determining the scope of the search. So not all probationers are subject to the exact same conditions, and there are circumstances in case law where, for example, if a probationer lives in a home with other people, then only certain areas of the home are subject to search based on the condition of that probation, specifically common space and space that is their space, but it wouldn't include their mother's bedroom or some other spaces. So when we ask questions about probation and the nuances of their search clauses, we'll ask questions that help us understand what lawfully we can search and make sure we don't overstep.
Isn't that in the record that you've checked?
No, but let me give you another example. So if I stop a group of people in a car and the owner of the car is on probation, then I have the lawful authority to serve the search condition on the trunk. But if a passenger is on probation, not the owner of the car, not the registered owner of the car, then the scope of the search is limited to the interior cabin of the car or the lunge, reach, and grab of the person in the probationer. So asking questions about, tell me about your probation, can clarify the scope of the search. How much are we going to be searching?
So I have were you finished? I'm sorry.
I think so. And then there was a couple other language changes about terms like detainee and making sure that we use a term.
Where was that?
In number 1 at the bottom it says to protect the safety of others, the person detained or officers.
Right.
We substituted that for detainee, and also there was some concern about in that line. I said originally it said to enhance, and you had some question about sort of what that meant.
Right.
And I changed it a little bit to protect. So it's less nebulous and talks about protection of the safety of others, the person detained or the officer. So that's kind of my stab at trying to incorporate the concerns we talked about last time.
Why, on number 1, why are you saying, why don't you use the language of imminent threat, or when, instead of saying to protect the safety of others, why not say when there is an immediate threat to the officer or others? I mean, I'm just curious. Was there a reason?
So not all threats are imminent. Weapons violations, for example, might not necessarily pose an imminent threat. Depending on
when there's a threat.
Yeah. So I was having a hard time, I think. You've proposed that several times.
I have. Sorry, I don't remember.
Well, you proposed it in the, and I understand in a sense, but what I'm having a hard time with is trying to make that teachable, trainable, trying to make it good guidance.
Because there is apparently in the use of force a definition of what constitutes a threat, right?
I think we're.
Yeah, I mean,
I think it makes it very difficult to teach.
Yeah, it just starts to get into the weeds as far as like what is an actual threat. I mean, the officers are trained to determine, if they need to take certain actions. Like, do I really need to put this person in handcuffs?
I'm just thinking about trying to make this different from current policy, because what you've told us all along is kind of like you're doing these, asking the question and doing the searches in order to enhance public safety. And so I want to make sure that this policy is different from that.
This is very different. So up until now, there's been sort of no guidance for officers about this question and its impact on communities, disparate impact on different communities. There's been no discussion. And consequently, there's a lot of differing views, even within our police department, about, well, should we be asking this question, and what about the officer safety concerns, and what's the training on it? And maybe one sort of training was going one way, and another sort of training was going another way. And so this, for the first time, very strongly states that basically you should not be asking this question. And if you have to ask the question, it should only be in limited circumstances.
Okay.
So we're changing the whole approach to this question
Okay,
in
that's good.
acknowledgement of the impact it has.
What I would ask is that this first whole paragraph, and we talked about this last time, talks about, because I'd like to talk to now only about the question, because that's something that we seem to agree on making some changes to. This first paragraph here, why can't we that pertains to searches. And I'd rather just be talking now about the question.
Okay.
We asked you last time if we could eliminate that first section.
Yeah. So I think this is the position I've taken and discussed it with command, is that it dilutes the impact of the contextually to separate that away. So we already have a statement very similar about searches in our B4 and in that policy. We have a sort of a statement about bias playing no role in legitimate law enforcement in there. So I think last time you said maybe we take that out and we put it over here, and then we take this search stuff and we put it in the search section.
Was it your intention to have this door closed?
Well, it was noisy.
Somebody was, yeah.
So by leaving it together, I think it gives impact to the issues, the underlying issues, that we shouldn't be asking this question because people are gonna, it's impacting our relationship with the community. People are
The problem is that for me is it conflates the two, and I would not be prepared to vote on this as it stands, because I don't want to vote on anything that entrenches the search issue
So this is
in this.
so where I was thinking this probably more sort of the place that makes sense for this policy to live to me is in the search and seizure policy. So the question of are you on probation or probation, which leads to searches, this first set of paragraphs is sort of the nexus to talking about the question in the context of probation searches, probation search clauses. Because that's why we're asking if somebody's on probation or parole, is we're trying to find out if they have a probation search clause.
Well, I understand that, but I don't want to. I don't want to affirm the thing about search conditions being consent and so forth and so on, because later we might want to have parameters put around the search conditions.
So you're talking about the first paragraph, probation, parole, post-release include search conditions either consented to or mandated by
Yeah,
law?
I mean, because that kind of affirms the search conditions as they currently exist, and we might want to.
So
you know,
that's the state of the law. So that's a legal statement about the law.
I know,
Yeah.
but do you get what I'm saying?
I do.
I do.
You
Okay,
I do.
so
you
I mean, we might want to, when this is all finalized, we might want to have the search conditions come first and then the question. But for the time being, we want to agree, we as a committee want to agree on
the
the
issues around the
question.
question. Okay.
Yeah,
Okay,
and
so
we can't do that as long as it's, let's say, contaminated by discussion of the search conditions.
Okay, so that would be just the first line then that you would.
Yes.
Okay, so I think the second paragraph, these searches shall only be conducted for legitimate law enforcement
Still
purposes.
searches.
Yes, I know,
About
but
question.
we're going to. I mean, I don't know how we're going to end up.
Mhm.
Just, it's one subsection.
Yeah.
Just deal with that subsection.
I just wanted to
Okay.
deal with this subsection for the purpose of the vote. I mean, it may be that later we come back and are able to reinsert these two paragraphs
Okay.
with specifics about the conditions we've carved out.
Yeah, so
Yeah.
I guess I'm hearing you, and
Mm-hmm.
I understand that it sounds like you would be saying from everything from asking the question, we're getting pretty close. asking, are you on probation or parole? We're getting pretty close. But the other part, you feel like there's still
Yeah,
more
but I
discussion to
also,
be had.
yes, and I also have some other issues with the parole question.
Yeah, but
Yeah.
but
But we're getting
by
close.
separating that, we're closer.
Yeah, oh, much, yeah.
Okay.
I think the gentleman here stated that if it's a traffic stop.
Lieutenant
This
Gunn.
gentleman here.
Lu-
No, this one. Which one?
Sergeant
I'm
Fomby.
sorry.
Fomby?
Ms. Fomby. He made a statement that if it's a traffic stop
Mm-hmm,
and the driver is on parole or probation,
mm-hmm.
what would trigger the passengers to be searched as well if they're just a passenger in a car?
I guess they're asked the question. I
Oh,
mean,
that
the
was
question,
what you
Yeah,
were
that was
addressing.
what I was saying.
Yeah.
Is, so
What would trigger
The
that?
passengers wouldn't be searched.
if the driver was on probation and the passengers were not, the passengers would not be searched.
but the
if-
passengers would be asked the question. And under current policy, the passengers could also be asked the question.
Depending on
and then
circumstances,
searched.
they may be
Yeah.
asked. Yeah.
Mm.
So in the case of a passenger on probation, they might be searched and the driver might not. If that makes sense. Well, I was
So you're
talking
talking about
Yeah.
a stop where say the driver is on parole and nobody else is on parole, and for whatever reason the officers determine they need to search that vehicle at that point.
Yeah.
Nobody but the driver would be searched. The vehicle itself would be searched, and that's what he was talking about. Places in the vehicle that would be subject to search based on the status of the driver.
Just out of curiosity, if the passenger is the owner of the car and the driver is on probation, do you still search the car?
not the entire car. Just the scope is limited to the basically where the person on probation could
Okay.
reach in the vehicle.
Did you have something, Elliot? Okay. So, can I go through just minor tweaks?
You bet.
Yeah. If I understand, I was going to change should to shall, but I understand what you said about you eliminated immediately, so should stands there.
Okay.
I think that's right. I think instead of where, you should say if the person has currently identified themselves, right?
Okay.
It makes it more clear. In those instances, probation or parole status, and I would eliminate in the existence of search conditions, because we haven't gotten there yet. In those instances, probation or parole status shall be determined, because I don't think you need should there, because we want to say it needs to be determined by radio or mobile records checks, right?
Okay. So what I think there's maybe a problem with the word and. So in those instances, probation or parole status and whether or not they have a search condition should ordinarily be determined by radio or records check. So instead of asking, run the name, is what we're saying there. That's Miss Allamby's point.
Right.
Don't ask. If you have what you need to know
That's
to
why
run
I
the
said
name,
shall.
run the name. So in those instances,
I was just
Okay.
changing
Yeah.
should to shall.
okay, so that's
A should ordinarily, just shall.
I see what you're saying. Okay.
Eliminate should ordinarily, and I
Okay.
would scratch in the existence of search conditions, because we don't know what we're going to do about search conditions.
But this is just
So they either
about-
exist or they don't. So the person either has them
Yeah.
or they don't.
Right.
This is just
Okay.
about finding out how you find out. This
Okay.
isn't about
All
what
right,
you
that's
do.
fine. I'll grant you that. I understand what you're saying. I just didn't want any reference to searches yet, because we were going to discuss it later.
So
But
more
that's
to
all right.
discuss there, okay.
Yeah. If during the process of identifying a person, a person, officers need to ask the question, are you on probation or parole? The officer shall ask respectfully instead of should, right? And consider that people may take offense at the question, I think is more grammatical, but instead of to the question. Officers shall only ask when necessary. And then, to protect the safety of others, fine. To forward a legitimate investigative purpose, fine. For example, sorting out multiple computer returns on common names. I just, for the layperson, multiple returns may not be clear.
They may not.
They may not be. They may not
Okay.
be in the computer. They may be.
Where are they?
A conver-
Dispatcher.
So if I call it dispatcher.
How can you make that how
So-
can you add a word or two to make that more clear? Multiple computer or dispatcher,
Computer might do the trick,
okay.
because the dispatcher might be
dispatcher
looking at a
uses
computer, and
the
then we're having a
computer.
conversation clarifying it.
Sorting out multiple computer returns on common names. And I was gonna end the parens there because confirming status known to officers, fine, I'll put that back in. But I want to eliminate determining the search, the scope of search, because we're not there yet.
But that's still,
That's an
again,
example.
just finding out what is in the computer. It doesn't say anything about whether they can search or any of that. It just says, this is the information we have found from the return.
And protecting the scope of search protects the person on probation, and make sure that you're not searching more than you're authorized
Okay,
to
I
search.
just don't want to be confused. If we say determining the scope of search conditions, the ordinary person reading that would not understand that you meant in the law as opposed to now in our current policy.
That's
that
not
we're-
the scope of search conditions. That's physically,
Yeah, I
where are
understand.
we gonna search?
I understand. The
Scope.
the scope of the permissible search or something. However, I don't want that to be confused. You're talking about in the law, like as the DA has imposed it. Somebody reading this would think that that means in our current policy, determining the scope of permissible search or something. Do you see what I'm saying? We may curtail the condition, we may curtail what can be searched. And by whom? I mean, I'm just saying we're going to, but we haven't addressed that yet. So if we put this in the policy now, before we've even talked about search, permissible
So every
searches.
search we conduct has to be lawful. And the scope of that search, the areas to be searched,
I
has to be
understand.
lawful. And
Do
that's
you-
regardless of
are
probation
you-
parole.
I hear what you're saying.
What I'm saying is determining the scope of search.
We can
No,
put-
it may be that the scope of search is far circumscribed, more circumscribed than what it is according to the
But we
penal
would
code.
need to ask questions about the status of the probation. With the probation, we may have a conversation, and this is about asking the question.
Right.
We may have to converse with them about their probation to determine.
Okay, so
scope.
how can we,
How about qualifying this, determine the scope of search as defined by the BPT policy, whatever
So,
we finally agree with, or?
yeah, I think that there's a misunderstanding. So the scope of search would say, if we saw a return, it would say, you're allowed to search the house,
I
vehicle.
understand what you want to say here.
No.
Do you
I
want-
don't.
Yeah.
So the computer will tell us
I
if
understand.
we are allowed, based on the probation, to
That's right.
search these areas.
Yeah.
What you're talking about is whether, like for example, in Oakland, a non-violent offense, let's say that was part of the policy.
Right.
That is not something that's going to be in the scope of the search. The return that comes back from the computer, that's what we're getting,
I understand.
right?
I understand.
Those are two separate things.
Exactly, I understand that. But somebody reading this might take that to mean the second of those things.
So this was just an attempt to offer you, legitimate investigative purpose examples. That is a legitimate investigative purpose. The reason to ask the question is to suss out, am I searching the trunk or not? Am I searching your bedroom or your mom's room?
Yeah, but let's
You know?
just say, Lieutenant, I mean, this isn't the case, but let's just say, we were to say, the commission and the city council and everybody were to vote no searches. Okay? It's not gonna happen, but let's just hypothetically. Determining the scope of search would be misleading to say that, because we're not gonna search you. We're not gonna search you if it's for a nonviolent offense.
And why would we ever ask the question if we weren't going to conduct probation search?
Exactly.
But we're still
Determining-
dealing with asking the question here.
How about qualifying this as determined by BPD policy, current policy?
No, because we're not talking about BPD current policy. We're talking about the penal code or what the DA has imposed or,
Why don't we?
you know,
why
we're not,
Are we modifying that, or possibly modifying that?
no,
don't we
well,
approach
we're
it this-
circumscribing
why don't we
it.
approach it this way? if we ended up in a place where there were some significant limitations, let's go back and look at those words. These documents are alive. There's no reason we can't cut it out then. I really was trying to be helpful and give you a reason why somebody might ask that question. If it breaks because we do something
Okay.
different, let's go
How
fix it
about
later.
determining the scope of possible search? That would cover it. In other words,
What if I said instead of scope of search, I said determining areas to be searched?
no, I don't think that helps. I think scope.
That's what I'm asking.
Scope is fine.
Okay.
I just think we need to suggest here that the scope of the search according to the computer may not be the scope of the search according to your policy.
Okay, so tell you what, I'll take the note. I'll take it back. I'm not sure we're really in agreement or I understand it completely, but I'll take the note back and we'll, this is a living document. So if we broke this document because we created something different.
Sergeant
search-
Fromby said it exactly right. I mean, I think that there's the scope of the search, as the computer will tell you, because that's handed down by the DA or the parole condition. And in the future, there may be the scope of the search that is permissible by your department given the new policy. Do you see what I'm saying?
I do, but that's a
So-
yes/no question anyway. I mean, that's either yes, you are going to be able to under that policy, or no, you are not.
Well, that's the reason I just proposed determining the scope
So,
of
when
the
determining
possible
the scope is
Okay.
you are in whatever circumstance you're allowed to. You need to figure out how much searching you
Okay.
can do.
So the problem is, Lieutenant, if we agree to, I mean, I'm fine with going forward and then removing it, but the problem is if we agree with the way it's worded now, and then later we have some search conditions that are different and we want to go back, as you suggested, and have to revisit that language, we need to vote on that all over, the package all over again, right?
Well, I think we're gonna. Okay, so I think we're gonna go pretty contemporaneous through the issues. We're gonna keep working on this.
Okay.
So,
right.
So I don't.
All right.
I don't feel like you're making a commitment that locks you in.
Okay.
In the way that.
Leave
you've
it
done.
in for now then, that's
Yeah.
fine, as long as we understand what we're talking about.
Right.
Ultimately, the department values the feedback. We're going to take that feedback to the chief. He's going to make, those policy decisions given that feedback, given this process. So,
Well, he's gonna make policy decisions in terms of what he wants the department to recommend, and then we may not agree, but.
it could
yeah.
go that way. Sure.
Okay, so 3, can we say to confirm probation and parole status subsequent to a records check? Instead of to
Discovery
confirm the
proof.
existence of a search condition.
Okay, because you're putting some time in there.
To confirm probation and parole status subsequent to a records check. And with that language, I'd be fine to move ahead. I don't know what, I mean, I
With
think
this
this is a
part.
vast improvement on immediately asking people. Monsieur?
Well, I just have a question. I mean, it said that during the process of identifying a person, officer need to ask the question.
Mm-hmm.
If they use their radio, or if the person present identification,
Mm-hmm.
why would they need to ask the question?
Yeah, we
They'll either
found
know
out.
through radio communication.
Well, it's these 3 conditions. It would only be allowed under these 3 conditions.
So the radio doesn't. When you, let's say you gave me your name but not your ID, and I ran your name, the records that come back might include other people who are similar, close names, maybe a slightly different spelling, somebody who's given that alias before in the past. And so there becomes an investigation about trying to figure out that I've got the right person in front of me.
But don't you ask for identification when I've been stopped? First thing they're asked for is my driver's license.
Sure,
Well, that's
but
identification.
a lot of people don't either have it or provide it.
Sir, would it help? And I'm wondering if it would be less wordy to just say, if officers need to ask the question instead of during the process of identifying a person. Because that makes it, because it's not just in the process of identifying the person, actually, it's this other, these
Okay.
3, so we could eliminate that process of identifying. So if officers need to, and these are the 3 conditions under which they'd need to.
Okay,
It's clear.
Good, thank you,
I think that's a good note.
yeah. Commissioner Allamby?
Sounds good so far.
Okay, so what we have, let's go through it. Again, just to confirm that this is what we
Okay.
have. Officers should not ask if a person is on probation or parole if the person has correctly identified themselves either verbally or by presenting identification documents. In those instances, probation or parole status shall be determined by radio or mobile records checks. If officers need to ask the question, are you on probation or parole, the officer shall ask respectfully and consider that people may take offense at the question. Officers shall only ask when necessary, : 1. And I think you can line these numbers up, don't need to put them like bullet points, but to protect the safety of others, the person detained, or officers. 2, to forward a legitimate investigative purpose, for example, sorting out multiple computer returns on common names, confirming status known to officers, or determining the scope of search, etc. 3, to confirm probation and parole status subsequent to a records check. Is that what everybody has?
Okay, so on 3,
Mm-hmm.
sometimes I might ask somebody, this is what 3 was meant to cover, is, and subsequent to a record check doesn't work there now that I think about it, because sometimes, for example, I know the person's on probation, I go up to them and I ask them, you're on probation, you have a search clause, and I know that about them already. I know this person, I've dealt with them before, I'm there to do enforcement on their probation, and so to me, there are times when I just ask somebody to clarify that they're aware that they're on probation. So that's what that's meant to cover.
To confirm.
That's someone I know.
All right, so how about saying to confirm probation and parole status known to the officer? Because you don't want to just leave to
Okay, to confirm the existence of a search condition known to the officer. So we got the records discovered through record checks. Okay, so I'm sorry.
because you already said.
I'm trying to solve
discuss-
too many problems with this one line. So, I mean, these are complicated.
Or, you could say or.
It's already in.
Yeah, that's in part 2. Okay, I'm sorry. I'm confusing the 2 lines there. So
Do we not need a 3?
So in 3, to confirm the existence of a search condition discovered through record checks. So in that situation, what I'm trying to describe is, I found a record. I don't. When we were talking about trying to identify a detainee, I don't know if it's you or not. I have 4 John Smiths in here with probation.
Well, you have
Which
that
one?
under 2. You already have multiple.
Yeah, that's an example. Yeah.
I don't know that you need 3 because you've already said under 2, confirming status known to officers, the problem with different names.
So let me reason through that. If it overlaps, I would take it out of the examples. I would have it be its own reason because it's a very common reason. It's one of the more common kind of reasons. So
Yeah, because
if I gave it as an example and used it in 3, I would take it out of the example. If that makes sense.
I think the way you worded it makes sense. And the example is, it's you contact the person, you run them, you don't ask them, you run them, and then the return comes back, and then you say, are you on probation out of Solano County?
So you're arguing for which?
So on 3, so after you've already run this person,
Right.
it would be feasible for the officer to then ask this person.
To confirm.
The return comes back and it says, this person is on probation.
That's what I was trying to get at. That's what I
Okay,
thought you were getting
That
at.
might work. So your proposal is to confirm the existence of a search condition subsequent to a records check?
To confirm probation and parole status subsequent to a records check.
Yeah, that doesn't fit in any of the.
Because that's different from anything you said
Okay,
above.
so, okay, probation and parole instead of existence of a search condition.
Yeah. I
Okay,
mean,
so-
that's the example you've given before when you say you've learned and then you come up and you just say to the guy, are you on, you're on
After
probation,
you've done-
right?
after you've done-
After you've done a records check.
And then sometimes, the reality is, Mr. D, people sometimes, if they don't want to be discovered, they don't want to be ID'd, they give their brother's name, their cousin's name, they don't hand us ID, and then we run that information, and then maybe sometimes we ask them these questions to verify if they're being truthful or not. So those are kind of things. That's how it plays out when you're contacting people on the street.
Okay.
They might not know enough details about the cousin, and by asking those questions, you reveal that they are not in fact the cousin.
So we're all on the same page, Commissioner Allamby. How do you vote on this?
Well,
You having a problem with something?
yeah.
Which part?
Well, I just think number 2 and number 3 are just similar. So I don't see the purpose of number 3. And I've looked at it from both perspectives, and I
Well, it
don't
is
see
true
it.
that if you say confirming status known to officers, under 2, one of the examples is confirming
confirm
status
is
known
the
to
same.
officers. Isn't that really the same thing as 3?
Because
It
you
is.
verified it.
Mhm.
Yeah.
I was
It's
really,
the
I gotta
same.
tell you, I was struggling to characterize
Yeah,
the exceptions.
Sure.
So, all right, let me take a look at that. Maybe that could just become 2 things,
Yeah.
What do you mean? Oh,
Just 2.
just
One and
1 and
two.
2.
Mhm.
Or what I want to give some thought to is the weight of the exception.
Okay.
Like is it something that happens that officers need to know is okay? That's an okay reason to have to ask this question. And so I want to make sure I'm giving some weight to the ones that are important. And then if it's just like a little example, or you know, what I mean, you treat it
Okay.
differently.
So Gwen, would you be, I mean, if either that example will be taken out of confirming
Mhm.
status known to officers up above and 2 and put in number 3, or if we keep number 3 to confirm probation and parole status subsequent to a records check. To
Okay.
confirm probation and parole status,
Can I make a proposal?
yeah.
Yeah.
So, and I know the commission can do whatever they want as far as how
Yeah.
voting these things on, or that kind of thing.
Yeah, but I'd like to have if we could just pin this down now,
So
we're
what
not
I-
gonna meet for another month, it'd be nice to have something.
I would kind
Yeah.
of just propose, and you can tell me no,
Yeah.
obviously, but if we got to a clean language of what you want me to take back to the chief, and the chief says, yeah, we're all good with that, then we're all in agreement, right? It's gonna become
Yeah.
policy. So, what I would propose is I clean this up,
Mhm.
then we show it to you, we meet again,
Mhm.
and then I'll be able to tell you that the chief's okay with it, and it's going to become policy language or not.
So,
Okay.
You know, I mean, that's where
Mhm.
So
I can
either
tell you
we
exactly where we are at that
so
moment.
Okay,
either we have
sounds good.
3, but the chief was okay with what you brought to us today, right?
Yeah, I ran this by the chief. before I
Okay,
brought it
so
back to you.
either we have 3 to confirm probation and parole status subsequent to a records check. You could even add in there to confirm probation and parole status known to the officer or subsequent to a records check,
Okay.
and or subsequent.
That's your call.
Yeah.
Yeah. So
Or you have that as an example in 2.
okay.
So either way, but otherwise you got the wording down that we just went through.
I believe so.
Okay.
So I want to make clear that I can get the feedback from the chief
Yeah,
and bring
you
that
can
back
get the
to you.
feedback from the chief, and hopefully he's on board with all of that.
Can we get the wording in about your question about?
Yes.
If needed, right?
About
We just need to
identifying-
go through kind of one by
Mhm.
one with the chief on the changing shoulds to
Yeah.
shalls, and think through the impacts of that kind of changes in language.
Yes, and let him know that some of this wording from these first 2 paragraphs will no doubt be inserted somewhere in the document, but for right now, we only want to look at the question.
Understood.
Okay,
Okay.
great. And then when we
That's been my proposal. It's so much easier to isolate the question, because
Yeah.
we hear what people are telling us.
Right, good. Okay, so we won't, I go away on Saturday, won't be back for close to 4 weeks.
Okay.
And,
so
but let's
that'll
set
be
up
in
a,
October. Mm-hmm.
I return the 3rd of October, and we'll be jet lagged, but otherwise. So I'm looking at the week of the 7th.
Okay.
I return Thursday night, the 3rd, so the week of the 7th sometime, we could either, is anybody, I see Yom Kippur starts on the 8th, is that an issue for anyone?
Okay, so it's the week of the 7th.
We have a PRC the 9th.
The 9th, I see that.
Mhm. Is that a problem?
No.
We're not gonna have any paperwork to read for this.
I mean, if you wanna
Yeah.
pick the 8th and it works
Does
with
that work for
everyone
you?
else.
You too?
What day of the week is it? The
It's
That's
a
a
Tuesday,
Tuesday,
just
the
like this.
8th.
That works.
So Tuesday at 11.
Mm-hmm.
Elliot, does that work for you?
Tuesday, the
Mansour?
October.
eighth,
At 11?
yes.
I know I told you we're just gonna have 2 or 3 meetings, but.
No, it's important.
And I say for the next meeting, we just meet us as a group to finalize this question and begin our discussion maybe of the search, because I don't think this is gonna take more than 5 minutes at the beginning of the next meeting, right? And then begin our discussion of the search, and then at some point, we might wanna bring in, you had recommended some people, I don't remember
City
who.
attorney, maybe probation.
I'd like to hear from the Alameda County probation officer.
Okay, do you,
And get his feedback since he worked on the Oakland policy.
I mean, the PD that worked with him.
Mm-hmm.
you mean the public defender?
Public defender, yes.
Oh, you said probation officer.
I meant, yeah,
we
yeah.
kind of heard some of that perspective today.
Yeah.
Yeah.
Do you have I mean, it's not necessary that we have, and we also have, it's gonna be lengthy commission discussions too, so it might be that,
It may be that when this goes to the full commission,
that's where we should,
maybe some of it, some yes, some no. I don't know.
yeah.
I could probably arrange somebody to come from probation. It wouldn't be the chief of probation. Obviously, it'd be somebody who works at probation. It really depends on sort of what the right approach is.
Well, why don't we meet by ourselves next time, and we'll see how
Figure
the
that out.
discussion is going, and, whether we need other opinions. I think we know who's coming from what side, and, I mean, I don't know what the probation officer, I don't know what he'd have to
The
say.
probation officer could be pretty informative,
Uh-huh.
because I think I've heard a lot of when you don't work in an industry every day, you don't know the nuanced things or how things actually
Right.
go, or
Yeah,
what's,
I mean, we raised a lot of questions today about it.
yeah. And somebody from probation could sort of give some life to what it's like to be a probation officer and manage a caseload, and why they do what they do, and why searches might be important.
And some of the numbers, right?
Sure. Okay. I could start working on that, and then maybe next meeting we'll figure out when.
In other states, it's the probation and parole officers who do all the searches.
Mm-hmm. Right.
But it's a very different systems in different places, and they have
Oh, I know.
probation officers or parole agents that are in the field, and that's just not.
And some states have laws where the parole and probation officer is authorized to, or requests of the police officers to do it.
I think the issue is that, you can't get there from here. We can't change how the state of California from here is set up to monitor probationers or parolees.
No.
Right.
And this is also, I heard the perspective of Mr. Prather. Really, I think if we're really looking at this, we have police agencies that have proactive teams that their only job is to actively monitor people on probation and parole.
You mean in California cities?
Absolutely.
Uh-huh.
And so we are the complete opposite of that. We are passive, and we might come across somebody who's on probation or parole on our calls for service or on a car stop, but there are other agencies that are proactively out there holding people accountable to their
Right.
search conditions.
So, before I adjourn, is there public comment? Christine?
Well, okay. Christine Schwartz here. I do the filming. Thank you all for coming. And thank you for Berkeley PD's services over the weekend. I really appreciate it. I forgot all about it until I was driving by close by People's Park and I saw you guys. Thank you so much for keeping us safe and for the great outcome of nobody hurt everybody going home safe, which is the purpose. The commissioner from Oakland just left a while ago, and I wanted to apologize recently about the shooting I heard about the mother of 5. I guess it was some kind of bystander shooting. It was really sad. So these instances happen, and my interest here goes down to, you know, people's safety, and I realize there's an issue, or I'm not sure if it's verified or not, but for some folks they feel like there is an issue. However, I'm concerned again, and I've stated it before, that when you ask the question, are you on probation, it seems to me that basically you're getting some information that's useful to the police officer to enable them to conduct their job safely and keep people protected. There is a purpose, I think. And I want that to be held, you know, with high regards. So, you know, not to offend folks, but, you know, just to keep people safe. I think there was an instance where, had this question been asked, a long time ago there was a gal who was kidnapped, and I think it was UCB that found her. Had an officer been able to ask that question, or remembered to, she would have been found a lot earlier. So there are actual, you know, instances where this question is very useful, and the examples that Sergeant Fomby brought up about the guns being, or weapons under the seats, is a big time issue if I'm not mistaken. And, you know, precautions, prevention is very important. So thank you again for all your time. Thank you so much.
Thank you. Our meeting,
If I might
yes.
just say, you know, for me, as an African American male, I've been stopped so many times in my life, in every jurisdiction, Los Angeles and Dallas and here. You know, we want equity. That's what we're looking for. You know, we don't want bias to come into the process of who's stopped and who's not. And as the young lady stated, I mean, there's a lot of crime, serious crime, that could have been prevented if the information presented to the officer would require them to do a search. In some instances, based on race, and many times they don't follow through, and they leave a dangerous person on the street.
Thank you. All right, well, have a good month.
Okay, and I'll
Meeting
see you
adjourned.
tomorrow.
See you.